Request for production is like another form of discovery. I am wanting to discover, instead of an answer to a question, I want to discover documents, or I want to discover the condition of a piece of land, or I want to discover the condition of a person because they're claiming more injuries than I believe they have. The way or the vehicle by which you accomplish getting production is by a request for production. Some jurisdictions, like interrogatories, will have limits and say you can only ask for 30 requests for production. Some jurisdictions don't have limits. Whatever the case, the key is that I am asking for certain information that is related to my cause of action, or that is in defense of the lawsuit that's filed against me. Let me give you an example. Please produce all documents that support your claim that there was a breach of contract in this case. Please provide the substance and content of what each witness will say to support your breach of contract action. Please provide all of your emails that you believe support that payment was not received. You see what I'm doing? I'm asking for documents. When you get to things and people, for example, I might want to ask them to produce the land for inspection. Now, obviously, they can't actually pick up the land and give it to you, but you're using that terminology to say, I want to go and inspect that land to see whether or not the damages are what you say they are. For example, an insurance company that's being sued because they didn't pay monies that were caused by a property damage occurred as a result of a storm may want to go to that property and actually see it so that they can verify whether or not the damages that the property owner is claiming are accurate. Now, obviously, the guy can't pick up his house and mail it to the insurance company. The insurance company still wants that to be, quote, produced. So it does that by way of a request for production and asking for a request to inspect the land. In personal injury cases, for example, a lot of times there's a question as to what the nature of the injuries to the plaintiff are. So what you might do is request for an inspection of the person. Obviously, they don't mail the person to you, but you might want, for example, an independent medical examination or another doctor to inspect the records and to perform some tests on the person to verify or challenge the actual nature and condition of their injuries. That's still a request for production, but it is asking for production of the body. So you can see that the key to these requests is I'm asking for documents, for things, for people, for property, in order for me to either understand the strengths or the weaknesses of my case. In response, just like interrogatories, you need to respond exactly number by number to the requests that are made. If there are 10 requests, you should have numbers 1 to 10. And you should respond with as much detail as would properly allow that party to understand what you're giving. For example, if I had 100 pages of documents, I might say the response to your request for all the documents that support my breach of contract are contained in the Redwell folder that is numbered in the bottom right corner, number 0001 to 0100. So that then you have a record of the documents you're giving, and they have a record that it's 100 pages. And that would enable you to understand what the document request is asking for. If you want to be more detailed and more professional, then it's nice if you could actually list out what those documents are. Pages 1 to 10 are the contract. Pages 11 to 20 are emails between the parties confirming the contract. You can see that I'm now giving a roadmap. I'm helping them by showing them exactly what is responsive and that it proves that I am right and they are wrong. I should recover or that the other person shouldn't recover, depending on what side of the V that you sit on. So you can understand that in responding to production, you can't just say, see attached. A lot of people do that. That's not the right way to respond. Now, you're not required to create all kinds of new lists when they're not created. Like in the case of business records, you can provide them in the order in which they are found. But the best practice is to always try to organize them, if you possibly can, in a manner that is usable to the other side. You're not afraid of what you're producing. If you are, then you need to be concerned about how you can resolve that matter, rather than concerned about how to hide things. So you can understand that it's important to respond properly. Typically, like interrogatories, there'll be a certain amount of time, say 30 days from the service of the production request. Now, oftentimes a court doesn't want to get 100,000 photographs or 1,000 pages of documents. So you will file your response, that page that says numbers 1 to 10, that lists the documents, but you will not actually give the documents to the court. You will serve them on the other party. So you can see how that is done. It's important if you're making multiple requests to number them. So it's plaintiff's first request for production, plaintiff's second request for production, plaintiff's third request. Don't just say plaintiff's request for production, because then you don't know how many there are, and it's hard later on to refer to the one particular one when they all are named the same. If you're responding, it would be plaintiff's response or defendant's response to plaintiff's first set of interrogatories. You see what we're doing? We're being what I call directional. That is, anybody can see what I'm responding to exactly, so that if later on we need to refer to that, we can do that in a way that is meaningful and manageable. Again, like interrogatories, you have the right to respond. You can either produce the information or object. You can also, contained within that sort of phraseology of produce and object, is perhaps you don't have them. You're still responding, you're just saying none instead of producing the actual documents. If you know their location and you believe it is appropriate to tell them, you could say, I do not have control of them, but they are in possession of the accountant. If you know where they are, it's fair to tell the other party where it is. And a lot of times instructions will say, if you don't know, you need to tell us where they are. You can also object, as we mentioned, and you have the right to object on any number of fair grounds. For example, if they're asking for documents which invade the attorney-client privilege, they want the letters between you and your lawyer. That's not permissible, generally speaking, and you would object based on the attorney-client privilege. But in most jurisdictions, if you object, if you're not going to produce documents, you must prepare what is called a privilege log. That is a separate piece of paper that says, here's the name of the document, here's the date, here's the general content, like letter from defendant, or letter from client to attorney regarding proposal. Enough information so that the other side can at least understand what the document is, and it also provides a guide for the court when the court reviews those documents, because obviously you're not going to produce them to the other side until the judge sees them. And the judge, after you file an appropriate motion, would actually do an inspection of the documents to determine whether or not they should be protected by the privilege. That's called an in-camera inspection. I mean, actually in his own presence, looking at the documents, he or she, and determining whether or not those documents are actually subject to the privilege. The way you do that is by way of a motion. For example, if they have produced a privilege log and it has a number of documents on them, you might do a motion to compel production of documents or a motion to compel full responses to the defendant's first request for production, and then you explain why you believe, based on the titles, those documents are not privileged, or those documents shouldn't be protected. For example, there is a privilege called the work product privilege, and that is a privilege that protects against the opinions of a lawyer, the expert communications between experts and lawyers from being produced. So if I've hired an expert, they say that there is a limited protection called the work product privilege. The product of our work should be protected. And the only way you can overcome that is by showing that you can't get it by any other method, and it's going to be an undue hardship for you to get that. So if I could take the deposition of the expert and ask him what the contents of those documents are, or if those documents were separately in the possession of someone else, then I might not be able to argue that it's impossible for me to get that, and therefore you should overrule their objection on privilege and give me them. However, if you're the one asking for documents and you can show there's no other way to get them, be impossible almost for you to get them without some extreme hardship, then you may be able to get a court to say, even though there is a work product privilege, we are still going to produce them. You have to look at each privilege to determine whether there are exceptions to the privilege. And most privileges have them, or whether the privileges are conditional or absolute. In other words, whether they provide for certain exceptions, or whether you can never get it unless there is a fraud, or unless there is a crime, or unless there is some specific act which triggers a right to waive or overcome that privilege. It's important for you to raise all proper objections, because if you don't raise them, you could be deemed to have waived them. So if you produce some of the attorney-client privilege material, you may have waived your right to protect production of the other attorney-client material. Unless you could demonstrate there was some inadvertent situation, you accidentally sent it, there was no intention of sending it, you can see how, if you participate in part, you may be deemed to have waived the entire privilege. There are other types of objections, like, for example, harassment or burdensome. Let's say they ask you to produce tax records and all accompanying documents from your billion-dollar company, and that is 150,000 documents stored in 6 different locations. Well, it might or might not be relevant, but you might say that is burdensome. That is harassing. I shouldn't have to do that unless, 1, I'm paid for it or somebody's paid for it, or 2, they first go through a process of asking for a lesser amount and seeing if that's enough. There are different types of objections to relevance. If a document is not relevant and will not lead to relevant admissible evidence, then an objection of relevance would be appropriate. Recognize that an objection based on that it's irrelevant does not work if the documents they're seeking will lead to relevant admissible evidence. So understand what I'm asking for when I'm requesting. The document itself may even be somewhat irrelevant, but if it could lead to relevant admissible evidence, then I cannot raise the objection of irrelevance. So you can understand there is a list of objections, and you need to appropriately make them in their proper stead based on the specific questions that you have. If you do that, you will understand both the process of the request and the process of the response. One last note on responses. There are times when it is difficult for you to get those documents copied, or it is difficult for you to process that request in a way that would get them the information. So you might say in your response, these documents are available for inspection and copying, upon a reasonable time or upon a reasonable request. The best thing to do, and the most appropriate and proper thing to do when you want to do that, is to make sure that you file your response with enough time for them to inspect the documents within the time prescribed by law. What do I mean by that? If someone sends you a request for production and asks you for 1,000 pages of documents, and it's going to be difficult for you to take them out and copy them and move them around, then you don't respond on the 30th day and say they're available for inspection and review and copying, because that's not fair. That's unfairly extending the time for your response. What you should do is on day 20 say, Opposing counsel, I'm writing you a letter. I have any of the next 10 days or some additional date beyond that you can come over and see the documents. Do you want to do that? Please write me back and tell me whether you'd like to inspect at one of those times. Then you can include in your response that exact time. Or if you respond after 20 days, you could put in the response they are available for inspection review within the next 10-day time period or at such time that opposing counsel deems it reasonable and necessary. So you can see what I've done. I've completed the request for production and the responses. And if you do that, you'll be successful both in interrogatories and production requests.